Thank you. We are going now to have a panel. I'm happy to introduce a panel on the practicalities of the implementation of the DMA. We are having 3 panelists, one of which is remote, but visible for everybody on screen. So this is Ana Malheiro. She is a case handler in the famous or infamous DMA unit. I don't know if it's a unit or a task force at this point in, at the European Commission. She has a long experience in DG Comp, has also worked in the Secretariat of the IMCO, so the Internal Market European Parliament Committee. So very knowledgeable of all the intricacies of the European institutions. We have also Carmelo, a professor at the Copenhagen Business School, the director of the Digital Market Competition Forum, the director of the Platform Economy and Regulation Observatory, and an affiliate professor at Bocconi, and one of the persons who has worked to bring the management scholars to the regulatory debate, to have a bit of a cross-fertilization. And last but not least, we have Mario Siragusa, senior counsel at Cleary Gottlieb. I understand splitting his time between Rome and Brussels, and also with the vast experience of the European antitrust law. So I think we are going to start with a quick presentation from Anna on the DMA to put everybody at level. Anna, you will have 10 minutes, and I'm going to try to be ruthless. So you can start.
It was just to say thank you, of course, to Nicola and the organizers for the invitation and making my remote participation possible. I also would like to congratulate the organizers for the quite spectacular agenda. The program is very, very interesting. I was not able, I couldn't join, but I really regret it, but maybe next time I can make it. So very briefly, and I was able to attend the last part, and maybe the good news, since you were struggling with the importance of market shares, is that market shares are not important for the DMA anymore, so that's maybe a positive side of it. But very briefly, since I only have 10 minutes, I would like to start by going briefly back to recall why are we here today, why do we have the DMA at all? And of course, this is the DMA is the outcome of a quite long reflection process that was informed by our experience on antitrust cases, and the realization that we and you have that to tackle a number of systemic issues in the digital economy, that antitrust alone was not efficient, and that there were some risks related with under enforcement. And this basically led us to the DMA. A number of other jurisdictions made the same reflections. They were just not as quick as we were. But there was, I mean, the US, the UK, Canada, Japan, they all went through the same reflection process. They come up with different concepts of bottleneck power, strategic market status, or substantial market power, whatever it is. We are more or less all talking about the same things. We came out with this concept of the gatekeeper, which was the option of the European legislators, basically. At the proposal of the Commission. The second point I would like to make, after going a bit back in the history to make understand where we are, is what are we trying to do? And I think that's important to start the discussion, is to recall a bit what are the objectives of the DMA, and they are threefold. The first is obviously the harmonization of the internal market, and this is something that for the European Union is very important. It is also very important for innovation. It's the best we can give to our companies and the companies abroad, is to give uniform, clear rules for everyone across the EU. That's quite spectacular. That's what we have been doing in all areas of the economy. We have a legal basis to do that, and we used it. So I think that's a good thing. The second point is the contestability and the fairness. What are they? Everyone is asking. So first, contestability. First, they are defined somewhere in a little recital on the DMA. But basically, the idea of contestability is this idea that is the ability of companies to overcome barriers to enter or expansion. This is, of course, it's a concept that is not alien to antitrust. You all know that better than I do. But it goes beyond antitrust, in the sense that in antitrust, basically, antitrust allows you to impose remedies that are related to the content of companies, and the DMA goes beyond this. The remedies are not related and conduct specific. The remedies are specific to the market, to the systemic failures that we identified in the market. This is completely different. It goes beyond. The second is the concept of fairness. Fairness is also not a concept that is alien to antitrust. And it is, broadly, we can define it as something like an imbalance of rights and obligations that translates into some disproportionate disadvantage, in this case to the gatekeeper. Both concepts are intertwined. You will see this is also recognized. You will also have sometimes difficulties maybe in singling out what is the one that is just about fairness, because they are intertwined. But this is more or less what makes the DMA different from antitrust. Is the fact that the remedies go beyond the conduct. We are not just looking to the conduct of companies. And basically we arrive to this. The other specificity to the European Union is the fact that this is an exercise that has been made by the co-legislators. So in a way, after an impact assessment, after a huge public consultation that took place, and then after gathering all these views, this goes to the Parliament and the Council, and they made a final judgment, and they struck the balance between all the different interests at stake, being innovation, being efficiency, being legal certainty, the need for contestability. All these ends up in the DMA. In this. So what are we doing basically? What we are doing is, well, you know, I will not enter into much detail because everyone knows this already by heart, but more or less you have the concept of gatekeeper. There are three major criteria, concepts, this idea that you are a gatekeeper. To be a gatekeeper, it's important it needs to have an impact on the internal market. The activity is a gateway between business users and users, and then you enjoy this position for quite some time. This is more or less what the regulation says. Then there is a presumption related to this, a quantitative presumption, and when companies fulfill these presumptions, these thresholds, they are obliged to notify, and the Commission, after this notification, adopts a decision. Companies need to comply with the obligations 5, 6, 7, and some others. But this I will not enter into detail of. This is more or less in a nutshell. The Commission may also designate companies that do not fulfill the quantitative thresholds, but it can go through, it can open market investigations to do what we call qualitative designations, taking into account other factors. But this, so where are we right now? In a couple of weeks, it starts the 2 months period companies have to notify. We already start engaging with companies quite some time ago. We already received some draft notifications from some of them, I would say from most of them actually. And what we are doing now is setting the machine, putting the machine ready, adopting, creating procedures, implementing regulations, which should be adopted and published anytime soon in the coming days, I expect, or maybe 1-2 weeks maximum. And this is what we are doing. We are having a close dialogue, not just with gatekeepers, but also with the potential beneficiaries. A number of workshops took place already. For those who are following closely, we have discussed already self-preferencing, interoperability, the provisions related to app stores, and on the 5th of May, there will be a workshop dedicated to the data, the provisions related with data. So this is, of course, uncharted territory. It is for us, it is for you, it is for the gatekeepers, for everyone. I think that the Commission is now, of course, in a different position. The Commission is the burden of proof is not anymore on the Commission, on the one hand, and on the other hand, the Commission has more powers to enforce. The DMA is quite generous in that regard. There are a number of provisions that allow the Commission to go after non-compliance. And I think companies understood this. They understood that the DMA is a one-of-a-kind regulation, and that's a new form of engagement needs to start. And that will also be prolonged throughout the time. It's just not maybe like antitrust specific to one case. This is the beginning of a long story. And basically, maybe to finalize in a positive note, the impression we have is that companies actually realize this and have so far been very engaging with us in a very cooperative way. So this, if I'm not sure if I exhausted my 10 minutes.
No, you're perfectly fine. Thank you very much, Anna. So I think this was a great summary, and with a bigger picture, I think that was very useful. And so I have a first question here for the other panelists, and it's about the objectives. So to what extent this new form of regulating that includes a lot of dialogue, but at the same time a lot of presumptions, but at the same time not a lot of analytical framework. So it's a very novel and uncertain formula. But to what extent do you think the objectives are guaranteed? So how do we get to fairness and contestability? Do we have the right formula with the content of the DMA and the process that seems to have some dialogue in it? So what can we expect? So Mario, why don't you?
Thank you very much. Yes, let me first just to respond to something that Anna just said. Of course, one of the basic assumptions which motivated the European institutions in enacting the DMA, as Anna said, is the fact that the unsatisfaction with the competition rules. But let's not forget that the original proposal was to strengthen the competition rules, was the competition tool that Mrs. Vestager had proposed, which then turned into a different project, which finally is the DMA. So the competition rules have their limits, but they have also their strengths. And one political choice which could have been followed would have been to strengthen the competition rules. Also because, as we have seen in the recent years, there has been quite a major increase in the implementation of the competition rules and the application of the competition rules in the digital work. And that, in fact, is the political choice that some member states have made, because, as you all know, Germany, UK, Italy, and some of the other member states have chosen to strengthen their competition rules, to lower the standards for market power, to increase the potential application of the principles of dominance, which is exactly one of the gap which was foreseen in the competition rules. But once I said that, let's answer the question which has been put. So, as Anna said, the two targets are contestability and fairness. Now, from an analysis of the structure and in particular of the obligations which are imposed to the gatekeeper under Article 5, 6, and 7, I think I have a number of comments. First of all, most of those obligations are obligations which were already decided in antitrust cases. All the obligations of Article 5 and most of the obligation of Article 6 comes from the experience which the Commission has developed in the application of Article 102. Second comment, the fairness and most of the obligations imposed by Article 5 and 6 have to do with fairness, because they really relate to the relationships between the digital platform and their users. So, introducing a number of obligations to improve and to make more favorable to the users access, use of the platforms. There is only one, in my opinion, only one obligation which has to do with contestability, which is Article 611, the one which addresses the question of data access to online search providers, so that the platforms are obliged to share data, raw data, but we can go into details later on if you wish, to other search providers. This is the only provision of the entire DMA which really addresses inter-platform competition, which I think is really what contestability means. All the other obligations relate to fairness. Now, of course, there is some relation between fairness and contestability. Of course, if you improve fairness to a certain extent, you do improve contestability between the various platforms. But again, this is, I think, a very important characteristics of the entire structure of the DMA, so that platforms are left to be totally vertically integrated if they wish. There is absolutely no intervention which is typical of other regulatory systems which we have seen in other sectors, but this has not been done in the digital field. Second, what are really the obligations of Article 5 and 6? And then there is, of course, Article 7, but I will focus mainly on Article 5 and 6, which really are obligations which go beyond what could have been done under the antitrust rules. I think there are very few. As I said, most of the obligations were already established under competition rules. The only one which I think do indeed go beyond what was possible under the competition rules are probably Article 5.2, which prohibits the combination of personal data without the consent of the end user, which, as you know, has already been the subject of very important cases like the Facebook cases in Germany, in Italy, and in other countries, where, again, most of the results have been achieved either under antitrust rules or under unfair competition rules. But here there is a step forward because some of the justifications that are possible under the GDPR have been eliminated by the regulation. In particular, the legitimate interest justification, which was one of the major justifications under the GDPR. So here the obligation goes beyond what is possible under the GDPR. Then, of course, there are all the Article 5, 4 and 5, 5.7, 6.3, 6.7, which are the anti-steering provisions, the use of AD services, or browsers, payment services, app deinstallation, interoperability, which have an impact, I think, mainly on the platform which are closed platform. I think those type of provisions will have an effect on the system which are closed. I think about the Apple system, but not on the systems which, of course, have already opened and which, to a great extent, I think, do respect those principles in any event. Then there is the section 6.5 on equal treatment in ranking, which goes a little bit beyond what already, of course, we derive from the antitrust case law, because it applies to all search, also in marketplace search, which it's, if you want, it's a little step further from the Google Shopping case. And finally, as I said, there is the only provision which is a real inter-platform contestability provision, which is Article 6.11 on the sharing of search data. So what is going, since the panel was supposed to discuss, what are the practical effects of the DMA, as I see it? I think we can draw probably a couple of possible preliminary conclusions, which I would like to put to you also in a provocative way to increase our debate and our discussion. The first one seems to me to be that the real impact of those platforms of the DMA is on the few provisions that I mentioned, which clearly have an impact which goes beyond what could have been reached under the antitrust rules. But the most important impact, I think, is not going to be on the large, big platforms, which were in any event subject already to Article 102, but of the medium-sized and small platforms, which, because they did not have the requisites for the application of Article 102, are now subject to this regulation. So I think that's where really we're going to have an important impact, because of course the second-tier platforms would not be subject to Article 102, because presumably they will not have a dominant position, and under the DMA, of course, they will be subject to obey to all the principles and the obligations contained in Article 5 and 6. So that is my first conclusion, that this is probably the most important impact that the DMA is going to have. On the other hand, for the contestability objective, which was one of the objectives of the DMA, I think that the real tool, if we want to seriously progress on the contestability, is not going to be the DMA, it's going to be the antitrust rules. And I stop here. Thank you.
Okay, Carmelo, do you have any reaction on the objectives and
yeah, so a few thoughts on this, on the objectives. So contestability, abilities of companies to overcome barriers of entry. I'm quoting Anna. So
you are quoting the regulation.
Sorry?
You are quoting the regulation.
Yeah. So, you know, I think that, you know, at the end of the day, if you really consider what the DMA is doing as a new institutional framework, is going over beyond the contours, right? That used to be the markets, as we understand. And for this, you know, is introducing new sort of objectives and obligations to, in my opinion, deal with a broader, regulation of broader contours, which are the new value chains that, you know, the digital economy is bringing about, right? So the digital economy is not really changing, you know, how economy has worked. I mean, in general, right? I mean, we had in the past, value chains. We had markets, we have, you know, connectivity, we have complements, you know, it's not that we're bringing it right now. It's just that the digital economy is breaking some of those boundaries and is actually, you know, breaking some of those existing barriers of entry. So if you look at ecosystems, right, the digital ecosystem today, that's what they do. I mean, they restructure, redesign some of the, you know, existing value chains, right? They break across, you know, boundaries across markets and industries, and they make, you know, possible for small and medium, even individuals, right? I mean, actors in the economy to contest, right? To overcome those barriers, enter into even regulated industries and contest incumbents, you know, products and services. You want a few examples? You know, I can even be a competitor with my loft, you know, apartment in Milan to some of the powerful incumbents, you know, in the operating in the hospitality industries. And I'm doing it, right? I'm using platforms. I'm studying, so I'm using also for my own, you know, individual purposes. In the medical, you know, health sector, I mean, there are new platforms that we have fantastic, actually. Article on one of the special issues that David has also, you know, edited on California Management Review, where we show this, you know, Patient Innovation, which is a European platform that does, you know, foster innovations in medical devices and that basically flip the way that used to work, right? So I mean, it's from supply-driven, you know, research of years from companies then pushing down, you know, to products and medical devices. Now it's actually coming from patient, right? So they start inventing around, you know, solutions, and then eventually some of them turn into entrepreneurs, or, you know, they pass over to others in the industry, and then, you know, the innovation process basically boils down into eventually, you know, new medical devices, right? That adds to the plurality. So in a sense, I mean, if we really consider, right, I mean, what the objective should be, right, it's not just narrow objectives of barriers of entry to some specific markets, but it's actually fostering plurality of ways of producing things. And that's, I think, that it's, the flipping aspect and the revolutionary aspect of the ecosystem thinking. That, you're not just concerned with the consumptions or use, but you are actually concerned also with the production side, right? And how the productions is linked to the consumption. So it's new ways of organizing the economy. And now, obviously, what we observe is that, some actors can become really powerful in enabling this, but also very powerful in regulating how this should be, right? So how this new organizational form should be, because they envision this, right? So they envision these new value propositions. So if we look at in these terms, then, right, contestability should not just be looked at, between the specific number of actors that use and access a platform, right? But in the broader terms, how these different ways of organizing, right? The new service or and productions and consumption of new service, right? Affect overall the different value chains, the different alternative ways of organizing this, right? So in this sense, right, there are some articles, some obligations, right, that if they are conceived as they are, on the presumption that, that digital platforms are fundamentally infrastructures, and they need to be, as open as possible to allow and reduce these barriers, right? Obviously, you get stuff like the disintermediation and things like that, right? That are considered as, positive and that will lead to the, lowering these barriers of entry. However, if you consider, right, if you take a broader considerations that this might actually be different ways of organizing the economic activity, this assumption needs to be revisited, right? Because it might actually be that, some organizations perceives the value propositions for some users, some producers, right, some of these complementors totally differently. And, having a closer rather than open ecosystem can actually, foment and produce more of these innovations or a higher quality innovation or a different type of innovations and be actually, the way to contest, right, the existing ways of organizing in the economy, right? So providing basically what we in management, refer as, differentiated, right? In this case, it's not product, but, systems, right? So there is competition between, on the grounds of differentiations on how you regulate this. And so let me, this has to boil down to fundamentally to the purpose of the system. Let me give you a stupid example, okay? Obviously, because we all agree on how, roads need to be used by everybody, we impose, obligations that are clear-cut, no need to discuss that, with some speed limits. Within a city, you can drive at X speed, right? Why this X? Well, because, we understand that, if you go faster than that, you might kill people because they're crossing the street. Now, that's because, we all agree and share that, that's what a road is and why it is used and how it is used, right? Okay. So this is basically, like, for instance, digital platforms should work. Now, would you still apply the same obligations to the Monte Carlo street when the street gets closed for racing purposes, for those familiar with Formula One, you know what I mentioned, right? Where they close that and they turn that, city's road into, a racing circuit. Will you still tell, drivers not to go over 50 kilometers per hour within the city simply because, we presume and have an assumption that, you don't drive fast in a city, right, on the road. Now, this is the risk that can be at play, right, with some of the obligations that have been designed fundamentally on the presumption, in some cases, right, particular contests, right, that, on the presumption that obviously reducing or removing or imposing that obligations will open up and free up, more innovation and contestability, but applying that same principle to contest different type of ecosystem, right, that have other fundamentals, that they work differently, right, you might end up with a sort of this trade-off and dilemma, that you might actually break out, right, how that different ecosystem works, because it's fundamentally based on different purpose and objectives.
So I hear something that actually you coincide in something. So you notice that most of the provisions are actually targeting fairness. And you point out that actually what's happening on the platform is a joint production, an organization that jointly produce value. So in a way that it would then make sense that contestability is not so much the issue, and it's more the terms of that arrangement that we need to govern. And so maybe there's a mapping here, whether it was on purpose or not, but there's something maybe that is, the attempt is being done right. But the question is, if we're talking about production and joint production of value, is fairness then the right benchmark? Or what is it that we would be optimizing? What is it that we should be looking for on the platform? And with that, my question would be, is the DMA over-designing platforms? Are there provisions, because they're taken, as you say, from one case, and they're being generalized to all platforms operating a particular service? Is the DMA going a bit too far in prescribing business models and architectures on platforms? And notice that the subject of the DMA is a service, a particular service. There's a list of core platform services, but the provision, in fact, affects the entire ecosystem. So it's the service and everything that's on the service and everything that's complementary to the service that is jointly provided. So I'm going to go back to you and then jump to the others. Or if you want to add, then you go first.
I can reply very, very easily, very quickly. I don't see a model which is imposed. There are a number of obligations which, as Carmelo said, apply to all forms of platforms, or however they are organized. What I tried to say is that the only impact that I see on a specific model is the closed model. Because, of course, since most of the obligations are obligations, we tend to open the system, to give access, right? That's the characteristic of the number of obligations that I mentioned. Then clearly any closed system has problems under the DMA, right? Because it has to adjust to these obligations which oblige it to become an open system to a certain extent, to the extent of the specific obligations which are imposed. Less so for the systems which are already opened, of course. Those systems do not will find it much more easy to adjust to the obligations under the regulation. And I suppose that in most cases they already implement, because, I repeat, those are obligations which come from the case law under Article 102. So all the major players, if they are serious players, have already complied with those obligations, right? Okay, so of course, now the obligations become ex ante, so of course Anna is right, it's much easier for the Commission to enforce them. There is all this bureaucratic apparatus which is going to take care, of imposing and following the developments. So of course, that is the substantial change. What I try to say is that on the substance, the changes are the ones which I try to indicate. Then, of course, the framework is totally changed. I personally would have preferred a strengthening of the competition rules, exactly what Germany, UK, Italy have done, which I think would have been more in line with the entire system that we have. But again, this is the choice. The regulatory choice has prevailed in Europe, as often does, and has the limitations which I tried to expose.
I'm not sure the DMA targets only closed systems.
No, it targets everybody. Yeah. I'm saying that the obligations tend to bite more on the closed system. That's the only thing that I'm saying.
Yeah, open systems tend to monetize on data, and the data obligations in the DMA are very, very biting. So I'm not sure. It's just a different way of breaking. Basically, I think the DMA breaks almost every currently existing business model and prescribes a particular one. And so that's why, hence my question, are we over-designing and over-prescribing business models on platforms?
Can I do some self-preferencing? No? It's not under the DMA. I will be fine. I don't know, but but it's for knowledge purposes. Yeah, so I mean, I mentioned, this example thinking on one particular case where that we analyzed, which is a company that, as a platform, as a core business, the intermediation as a facilitation, so hospitality services, helping you book in hotels. Can you figure out what that is? Okay, so I'm talking about that company, right? So that platform. Now, or those types of platforms, right? Because I don't have necessarily interest in any particular platforms. But under the provision, under the obligations of 5.4, okay? So that I have here 6.10 of the DMA, okay? So for you, that now with numbers, for God's sake, it's afternoon, don't kill us. Basically, the 5.4, right, is prohibits, gatekeepers from preventing business users from communicating and promoting, to end users, right? Deals outside of the platform, right? So that it's call it, possible disintermediation of the platform, right? While the 6.10 basically force or gives the rights, to providers, to have access to data, right? So I'm quoting here: effective, high quality, continuous, and real-time access to and use of the data generated or provided, by their activities on the platform. Now, what happens with this? This was designed primarily in the case of app stores, right? Where you have, app producers, app developers that put, their apps there, and then, the platform doesn't allow you real communications, but so you cannot actually offer deals, but you have to go through the centralized, things of the platforms to conclude those deals, right? What is the problem? Is that you highly depend, on the platform, and you cannot do things like that, or you can even, overcharge users because, you have to pay the fees, to the platform. Okay, that's one aspect. Now, if you apply that to the, booking service, whatever, platforms, what is the potential problem is that you can actually break an entire set of economy that goes beyond just the hotels and people that books there. So we have basically this short piece that we produce, the monitor, where we look basically, we map visually, the broader ecosystem based on data that runs, around these platforms. There are all sorts of different programs. Some that are called affiliate, programs. Others that have, to do service that goes other complementary service like, riding and booking of local experience or activities in the city where you go. Other services that have to do with websites, blog content creators that create content to promote some particular contents of the websites, and as a way to promote either some facilities or activities in a city. That has, marketing basically impact on users, or why you then decided to book, for one or the other. And so all of those can exist just because they have, access to this particular data that are processed, centralized by the platform. What happens now if you do this intermediation? The sum of this can actually break, right? So the data won't be working any longer as effective as they are right now, simply for the fact that, if I booked for the platform, but then I've been contacted by the hotel, and so effectively disintermediated, that data, right, it's now off on the platform. What happens now? I'm actually booking the hotel, but I'm just not recording that on the platform. So two type of failures can happen. Either there's conflictual data signal, right? There is conflictual information that I'm not the kind of customer, right, interested in those things, while in fact I am, right? It's just that I'm not being recorded, right? And the other one is that basically because now I'm not recorded, so I don't have now all this information, so there is no possibility for the other service providers to offer anything to me. So we have other type of failure, which will be basically reduce activity related to the core activity, which is booking hotels, okay? And so those are, the second is greater failure in terms of economic activity in general, and some that is peculiar just to the digital content creation, which is this websites, blogging, etc. We might not consider that as innovation, if you want. I completely disagree with this, right? Because, in the digital economy, what I think, and maybe, we can talk about this later on, of innovations is more related to the number of new interactions that we can habilitate because, right, of the digital productions. And data, it's a core part of it, because, it's codifying information, processing that information in a way that can habilitate this, obviously can also prevent others, can also be used in an anti-competitive way. But that's the sorting of things we need to do. If we just go with the plain assumption, to open up.
I'm going to cut, and I want to turn to Anna for a second. So the DMA seems to give a lot of weight to businesses that need to use the platform and access the platforms. To what extent are the businesses that build on the platform, which is what Carmelo is just talking about, to what extent are they being considered? You mentioned there's a process of dialogue in the DMA, in the implementation of the DMA. To what extent are all aspects of innovation being taken into account? Do you think they're all properly reflected in the proposal?
Can I just exercise some rights of defense as well? I'm not sure if the
enforced of course,
but would be appreciated. First, just to react, I don't resist, Mario, just to tell you on the new competition tool, I'm completely aligned with what you say. And actually, from the continental can to the merger regulation, it took member states 20 years to agree. So maybe there's hope that in a couple of years we will have a new competition tool. Who knows? But just going back on the importance of the ecosystems or the whole platform integrated with other services, I think it's quite interesting because the way how I see it, so basically Mario says open systems. You say we are breaking up the platforms. It's semantics, and I say we are promoting contestability. And the thing that for me, it looks like we are all looking into the bottle. You are saying it's half full. I'm saying it's half empty. And it's interesting because having worked as well during the trilogues negotiations, for me, it's half empty as well, because actually the DMA recognized the value of ecosystem and is not fundamentally changing the business models of companies. Because if you look to the data provisions, for example, the DMA accepts and recognizes the importance and the need of some CPSs, notably online advertisement, to monetize other CPSs. And for this reason, target advertisement is not prohibited. And yet it was discussed as a possibility. And it's not because it's recognized that it is important. So what you see is already quite balanced. Other things, for example, is also the data combination. Data combination is not prohibited. It's allowed. It just needs to have consent. It's quite different if you would say you cannot combine. We are just saying you can combine, but you have to ask consent. Other things, the self-preference is linked to ranking only. And yet, during the discussions, there were some calls for having an outright prohibition, self-preference prohibition on gatekeepers. And this is not what you have. And also you don't see, and I think Mario hinted to that, you don't see any line of business restriction nor structural separation. And we know that many jurisdictions are asking for it. And this was also considered during trial negotiations. So what I want to say is that I see the bottle half empty, and I see that we are not fundamentally changing business model, and actually the value, the importance of integrated CPSs and ecosystems is well reflected. Is all about, as Mario said, opening up, not breaking up at all.
Sorry, I asked Mario if he thinks the balance is right. And,
I think the balance is right. I think simply, I don't know, Anna would think that such balance could have been achieved to a large extent by applying our competition rules, which are not so bad as people think about it. I think they're very good. And if they are fully enforced, I think they can go far away. But maybe we should ask I try to be provocative simply to try to have a larger debate.
Yeah, I'm going to leave the questions maybe for the end. 1 second, and I'm going to finish the round on this Over there, do you want to have a quick reaction to this?
You know, just
Yeah,
no, very, very quick on the. I'm glad that Anna, said that this is just semantic, because I mean that was purposely my point. So fundamentally I think that the DMA could be much clearer if you use language to say that fundamentally it's regulating the well-functioning of ecosystems, and to avoid failures in the broader ecosystem. Because at the end, that's what it is. And because those failures include both the contestability aspect and the fairness aspect, that, with just a strict focus on market, and just, on the substitutes, lens of the traditional antitrust, you will not be able to justify or clarify, or even from a logical point of view. But this is actually fundamentally ecosystem management. When you talk about fairness, you mentioned balance, right, between the rights and the obligations. It's balancing the contribution and use, right, that you have. So how much you contribute as a complementor, right, to the ecosystem, to the joint value that is being created, and how much of those joint proceedings you appropriate, right, as an individual contributor. That's basically what it is, right? And sometimes, we know that if you are the one regulating the ecosystem, managing the ecosystem, so the gatekeepers in the language of the DMA, you can potentially prevaricate, right? This role, and then appropriate more than what, you contribute actually, to the joint value productions. At the same time, if you had that, reorganize basically the obligations in terms of more of a principles of this ecosystem management, I think it will be much more clear, and even include some other aspects that we're yet to see, but are already there, right? That they are not in the obligations at the moment. On the other aspect, though, I think that that will also challenge a little bit the assumption of opening up forcing to open up the system is always, the good way of managing ecosystem, because it is not. And we have research on this, and we should start, to look also to the research-based facts, when we regulate this.
So it looks like we're on the right track, and the DMA is on the right track in the sense that there seems to be a need to start thinking about governance of ecosystem and finding a way that makes it work for everybody who participates. But I'm not sure that sounds like competition policy, which comes back to a question for you, Mario. You said we have all the tools with the competition policy. There was a debate about that. What we have seen now is, we know that DMA and 102 antitrust will be enforced in parallel. The Commission 2 weeks ago published a communication saying they're going to amend the guidance on 102 and republish guidelines, basically retire them and publish new guidelines. Is competition policy evolving towards the DMA? Are you going to get what you want in the end? Tell us a little bit about how you see that evolving.
Yes. So, what are the real huge changes which have come about, with the digital economy, the digital trading, and so forth? First of all, the decrease of intermediation, right? Because platforms deal directly with end users very often, right? So, Article 101, the article which applies to agreements in restraint of competition, is less applicable in the digital world, right? Because you often do not have, a distributor. You don't have an intermediation, right? So the room for agreements is, in particular vertical agreements, is less present as it was in the old economy. That's, I think, a very important change. And secondly, that there is, of course, an acknowledgement that even platforms which do not necessarily have a dominant position are important tools to go to the market, right? Are very important, platforms which may. So if there is no open, non-discriminatory access, there can be an unfair restriction of competition. That's why I think the major issues which of course, the DMA addresses is lowering the standard of market power. As Anna said, there is no longer a need to establish, market share. There are some, quantitative thresholds which have to be fulfilled, and then you are subject to the gatekeeper obligations. So that's precisely. And as we said, opening the system by making them more fair in relationship. The DMA is very specific to end users and business users. So basically, the users of the platforms have to be treated fairly, have to have the ability to access the platform and so forth. That's what I say. So, of course, as you are saying, competition rules are applicable, while the DMA gives exclusivity to the Commission on the regulatory side, so that member states should not apply regulations to the gatekeepers in a sovrapposition to the DMA. And as we know, national member states can start investigations on violations of the DMA, but the final decision, Anna, correct me if I'm wrong, it should be a decision of the Commission, right? Because that's what the DMA provides. The member states are free to apply their own competition rules. They are free to apply Article 102. They are free to apply their own competition, their national competition rules. And this is a very important factor, because one or the other, we have not talked about that, but one of the other objective of the DMA is to avoid fragmentation, to avoid that the regulatory scheme is changed from member state to member state. That's why the European institutions have those broad rules which apply across the system, right, with the DMA. But some form of fragmentation, I think, is happening, because, as I said, some member states have substantially improved their national laws, their national competition laws. They have lowered the standard of market power under their national competition rules. And as you know, under Regulation 1/2003, the Commission cannot stop procedures open under national rules. While they could, in theory, evoke to themselves procedures open under Article 102, they cannot do that with the provisions open under the national version of Article 102, like the German Bundeskartellamt is doing. So I think that there's going to be some form of fragmentation because of this ability of national authorities to continue to apply national competition rules. On top of these, the obligations of the directives are directly applicable by national judges. So you can have, in a litigation in a national court in any member state, you can invoke, the possible violation of one of the obligations of the DMA, and the poor national judge has to decide what to do with it. Of course, I suppose that the gatekeeper will have, in the meantime, negotiated with the Commission. As Anna was saying, there is this dialogue and the way to implement the DMA. So, in a sense, I see the DMA also as a possible shield for the gatekeepers vis-à-vis all this turmoil of litigation which may take place in member states, all these initiatives by the national authorities. If you have, an agreement with the Commission on a good implementation of the DMA, you can use that in the, litigation fora in the various member states in order to try to avoid this fragmentation which may take place. I stop.
Anna, I think it'd be interesting to have your view of how the Article 102 and the DMA will work together on one side, and then how the Commission will work with national authorities, because it's, I'm not sure I was reassured.
I maybe start with the latter, because I absolutely agree with what Mario said, and I think it is important, and that's why we have a regulation with the legal basis of the internal market. It's extremely important. I think that's why cooperation. We should not forget that there is the ECN network, and the ECN will play a major role it's not in the interest of anyone to have different enforcements of duplicating efforts. I think so. This is something that I think it will slowly change as coordination starts also at ECN level with the national with the national authorities and dialogue. So this is, I think, but I absolutely agree that this is something that cannot that should it undermines the goal of the regulation and also innovation. So this is absolutely not what I should say as well with regard to the involvement of national authorities. To put it from a more positive perspective as well, is that the regulation opens up the possibility for having joint investigations teams, including, and that would be something new, where we would be able to go a step further than what we did on Reg 1, and this time even having joint teams looking into the same facts. You can even have a national authority, if that's allowed by national law, to open investigations for infringement of the DMA, even if they don't have decision-making power regarding the DMA, but they can do that because member states can ask the Commission to open up market investigations. But this idea of joint investigation teams, I think it's quite, it's also positive. So I think, but I fully agree with the concerns, and but I think it's something that we are all working together on. No one wants to duplicate efforts, energy, resources, and no one wants to have a fragmented internal market. And now with this, in the end, I forgot the first question. I now I recall 102 and DMA, right? Well, I think it is.
No, just if you can mention also the revisions of the Article 102 that have been announced. I mean, to what extent they're being redirected to complement or at least achieve the same things the DMA is trying to do.
Well, on the revision of or amending of the guidelines, I will not say anything because it really goes beyond my area of let's call responsibility. I don't want to say anything that is wrong. So I prefer not to say anything in that regard. I think I'm not the person best placed to say anything about that. But regarding the 102 and the DMA, well, our directorate is responsible for enforcing both. And basically, the idea is that you will apply the DMA for everything that is more considered as more the type of behavior that is more egregious, more serious, and for which basically you think that you don't need to go into case by case because there is some consensus that this is wrongdoing. So it is in the DMA, basically. That's the idea. Where would you go for antitrust? Of course, we are now at this moment, we're asking this question, it's a bit too soon, because we are just implementing the DMA. So obviously the DMA covers many things, or almost everything, one would say right now. At the same time, we know that this is a sector with a great innovation potential, so I'm pretty sure that we will not be short on cases very soon. So basically, if you want a simplistic answer to this, it would be that right now, for everything that falls beyond the CPSs, obviously it would be for antitrust, or everything that falls outside the obligations, the behavior that is covered by the obligation. But it's something that needs to be assessed on a case-by-case basis, I would say. I always recall these constructive refusals to deal back when I was doing antitrust that always come in shapes that are much more complex than just saying no. And I think we could very well see type of behaviors that go beyond the DMA is very prescriptive, and that of course means also that it's less flexible. And luckily, this industry is very innovative, and so it also means that I don't want to suggest likely the DMA will be outdated, but what I want to say is that there is so much more beyond the DMA. I don't think that will be an issue.
Okay. Okay, one sentence.
No, very quickly on this. It's more a question, It's more a question on why or whether, because I think that, it's really about ex ante and ex post, right? I mean, so the case-by-case ex post that you really go deep into assessing, some specific practices, but also you have the trade-offs of the lengthy process, et cetera, and in the meantime, everything may have changed, and so then, when you get to the conclusion, it's irrelevant. With the ex ante that, as Anna mentioned, is too rigid and sometimes, right, I mean, too prescriptive, perhaps. And then it cuts across this. So, but my point is, first, can the DMA version 2.0, let me put this like this, version 2.0, right, become...
Be careful, because that can be very easily a tweet, and then everyone starts talking about it already. I'm pretty
no,
sure.
but because I love so much the DMA that I already foresee, the better version of it, which is 2.0. And the 2.0, will move from still ex ante, right, but more into type by type sort of regulation, right, where there is a much more link in between those, CPS and the type of obligations. Because as you said, right, I mean, there are some prescriptions that those are wrongdoing. Put in my own language, wrong, ecosystem management practices. But to have that, more appropriate should be linked more to what are the wrong practices linked to what are the type of ecosystem, right? So those CPC. And in this I see complementarities, right, between the ex post, ex ante, because the ex post can also then provide some inputs into new things or things that are not surfaced, in the DMA. That's it.
Okay, I think that we can conclude. I conclude from the debate that there is a very legitimate exercise to try to improve the governance of ecosystems and the behavior within digital ecosystems. It's unclear to me that we've settled yet on the right concepts and the right tool, particularly because we come from competition policy. I think there's still demands that competition policy is still the right tool. On the other hand, we're talking about a new issue here, but that issue seems to be not yet properly defined. And so the conclusion I have is that, yes, we will probably see an evolution of this. We will have now the DMA implementation, and we count on the Commission to continue to exercise a balanced, open ear conversation and implementation of the DMA.
If I may,
yep.
Could I just get to something? Antitrust is the right tool is only the one that brings added value and solves the problem, right? So I would I would say why we have now two tools. Why not using both or the most useful one? I don't think we need, as a matter of principle, to consider one as now that we just adopted this tool, we can very easily use both. That's my both, or as a matter of priority right now, the DMA.
Okay, so all tools will be used. And I don't know if we have time for questions. I think we're over time. So yes, we'll have to feel free to ask the panelists questions or by email or at the coffee break, and you will get your answers. Thank you very much.